गुड डे टू ऑल। मेरा नाम प्रदीप शुक्ला है। मैं कन्वेंशनली बॉम्बे में प्रैक्टिस करता हूँ सिंस 48 ईयर्स। और आज यूट्यूब पे जो जजमेंट मैं अपलोड करने वाला हूँ से रियली यूनिक जजमेंट, जो सो मेनी डाइवोर्स लेडीज़ हु आर नॉट अवेयर अबाउट देयर राइट विल बी बेनिफिटेड। फैक्ट्स ऐसा हुआ कि इन ए डाइवोर्स पिटिशन, कंसेंट डाइवोर्स था, the permanent alimony was decided for the wife also and a child also, and maybe out of emotion or maybe whatever may be the reason, but the wife waived her right for future maintenance. Subsequently, see what happens is that as on that day the mind may be different, but subsequently it was found that it was not sufficient amount for her to maintain herself and a child. So she again went to the trial court and family court, and वहाँ पे she made an application for further enhancement of the maintenance. The trial court did not allow her application for the reason that once you have entered into an agreement, you have waived your right, then you don't have a right to claim further. That was one of the strong point decided by the trial court. And secondly, that so far as the child is concerned, it is only permissible under section 125 of criminal procedure code about the maintenance of the child also. So even the child maintenance is also not applicable. It was vehemently argued, nothing else. But there was a rejection. Now, against this rejection, appeal was preferred by the wife. See, the tragedy is that the appeal was done in 2017 and it is decided in 2025. Now, apart from that, but luckily, the Kerala High Court at Ernakulam decided in favor of wife. That just because what was the finding of the High Court was that statutory right of maintenance is given to a lady. By agreement it cannot be go by. Means आपने कुछ भी against the public policy आपने agreement किया, but it will not be binding effect. So the High Court allowed the appeal of the wife. Maintenance was allowed. The second argument also that raised by the other side was that so far as the child is concerned, the family court petitions cannot entertain because the child maintenance is covered under 125 of criminal procedure code. Now that also the High Court held that no, it is not that way, that strictly it should be that the family court has a right to grant maintenance. Now here the question and explanation given by the High Court was the party, aggrieved party, means in this case the wife has to come with a complete statement how the current affairs is looking to that the maintenance that she has got is not sufficient enough with the change of circumstances. That is the only thing she has to prove. Honestly, why I said this is a unique judgment, क्यों कि बहुत सारी लेडीज़ जो डाइवोर्स के बाद में जिंदा रहती है उनको पता भी नहीं होगा कि दे हैव ए राइट टू डू दिस. सो दिस इज़ वेरी यूनिक जजमेंट.